Welcome to Internet Safety, hosted by Donna Rice Hughes. You'll learn practical and crucial tips on how to keep your loved ones safe in the digital world. Now, here is Donna.
Hi, everyone. I'm Donna Rice Hughes, and welcome to our show, Internet Safety with Donna Rice Hughes. Today, we are going to be talking about the growth of child online exploitation, the role of government, and big tech regulation. So, how do we protect our kids in an increasingly toxic digital world? And how do we get to a global pandemic of online exploitation where multi-billion-dollar criminal enterprises, including the child pornography industry, the pornography industry, sextortion, online predation, trafficking, and so much more, continue to thrive? And how do we get to the place where the multi-billion-dollar tech company industries continue to allow this abuse and to profit from exploitation with absolutely no accountability? Today we have two very special ladies, and I'm so excited to have them both. First, we have Mary Graw Leary, professor at the Catholic University Columbus School of Law. It's hard to get that one out. She recently testified before the U.S. Senate Judiciary Committee about strengthening protections and addressing legal gaps with respect to protecting kids online. And in her testimony, which I loved, Mary emphasized the misapplication of Section 230 of the Communications Decency Act. And she argued that this has created an ecosystem that not only fails to safeguard children, but also incentivizes the tech industry to endanger them and inflict harm with no accountability. Mary, welcome. Next, we have Haley McNamara. She is the Senior Vice President of Strategic Initiatives and Programs at the National Center on Sexual Exploitation. She leads joint campaigns within the areas of legislation, litigation, and corporate advocacy regarding sexual exploitation issues of both children and adults. This year, their famous Dirty Dozen list actually chose one issue, and that is the importance of repealing the Communications Decency Act, Section 230, as a top exploiter of children online. And Haley, I'm going to go to you first, but you also highlighted, instead of 12 companies, 12 survivors who were denied justice in the courts because of Section 230. So welcome, ladies, and Haley, first to you.
Thank you so much. I'm so honored and excited to be here chatting with both of you. And you're exactly right. Our annual Dirty Dozen list campaign since 2013 has been naming 12 different companies a year that facilitate sexual abuse or exploitation. So in the past, we've been targeting and thankfully getting victories from Google, TikTok, Hilton Worldwide, Walmart, Netflix, and many more companies. However, this year we did a really radical departure from our typical formula because despite these years of advocacy and exciting victories, sexual abuse and exploitation is still increasing and it's rapidly increasing online. So progress feels slow or piecemeal because of the single target that we then named this year, which is Section 230 of the Communications Decency Act.
Thank you, Haley. And I'm so glad you did, because this is, you can eat an elephant one bite at a time. And we're going to talk about how we've been doing that, in legislative efforts and advocacy efforts and in public education and awareness. But I'm going to just share for our audience. You all know these facts, and you can add some more statistics, but I'm going to go through some of the top ones because it's not getting any better, right? In spite of the piecemeal, incremental changes we're able to make to better protect children and families and adults online, it's still an exploding multi-billion-dollar industry. So here you go. Cyber Tip Line last year received 36.2 million reports of suspected child sexual exploitation. Those reports contained over 105 million images and videos, sometimes kids as young as toddlers and infants. Here's another one. Young children are being targeted on an industrial scale by internet groomers. In 2021, there was a threefold increase in imagery showing 7 to 10-year-old children. Online sexual exploitation and abuse of children has increased by 422% over the last 15 years. Okay, this is staggering, really. And I can keep going. Live streaming, kids, 98% of kids in a live streaming report that the IWF did found that 98% of the victims were under 13 years old. 300% increase in online enticement. Okay, we can go on and on and on. Mary, you're a professor. You're also a mom. When you see this, weigh in on just how bad this is.
Well, I'd like to put it in historical context to say how bad it is. When Congress saw the internet coming on the horizon, to their credit, they were worried about what could happen because prior to the internet, there was regulation in place with broadcast, there was regulation in place with time, place, and manner restrictions about access to pornography, etc. So they were thinking, gosh, this internet thing could be really bad. So why don't we put in similar sort of guardrails here so that we don't all of a sudden have direct access to children by potential those who are seeking to harm them, or shield families from some of this material that might be out there, but we've been able to sort of limit it within constitutional bounds. And so what I like to say is what they feared back in 1996 when they were thinking about the Communications Decency Act, it has far exceeded their worst nightmare, right? They, back in 1996, AOL was the dominant carrier. Google hadn't been invented. Certainly things like Pornhub didn't exist, and the list goes on. So today, to say that the internet is awash in pornography, that children are a great threat of various forms of exploitation online is almost an understatement for how it looks today.
Well, and you're exactly right. And since you went back to the history of how the Communications Decency Act started, I happened to be one of the people that was there. Enough is Enough was there. And we actually began working with Congress in 1995 and hosted a big event on Capitol Hill. It was called the Leadership Luncheon in the Russell Caucus Room. And Senator Exxon, Senator Grassley, Senator Dole were all up on the dais with me and the founder of Enough is Enough, Dee Jepson. And we introduced at that time what was happening, because this, ladies, and for our audience, this was not just pre-social media. This was pre-World Wide Web. This was pre-email. Okay, all of that was in development. And what we had seen happening on news groups and bulletin boards was astounding. And that's what got my attention. And so we thought, oh my goodness, computers, and this was in my speech that day, June of 1995, computers have emerged as the leading edge technology for the distribution of hardcore pornography and child pornography. And just as disturbing is the fact that we cannot protect ourselves or our children from those who derive sexual pleasure from viewing this toxic material. Several days later, the Exxon bill was passed. And the way we got it passed, because honestly, the senators, most of them didn't even know what the internet was. I know it's kind of scary, but they really didn't. And Senator Exxon, they were getting nowhere in talking about this idea, Mary, of what you were saying. How do we extend the laws that protected children from all of this content and sexual predation and everything else that we started seeing pre-World Wide Web, and how to extend those laws? Because we had laws that worked, right? We had laws that worked in the physical world. And so we put together what was called the Exxon Blue Book, and we printed out images, literally, into a blue binder. This was done in our offices, and hardcore stuff, bestiality, women being tortured. It was bad. And we intentionally made it bad. Senator Exxon passed that around. A few days later, after this event, the Exxon bill was passed, and it went to the House in what became eventually the Communications Decency Act of 1996. So our worst nightmare, Congress's worst nightmare, has all happened, and there's a real key reason it has gotten this bad, and that is Section 230. So, ladies, let's talk about the original intent of the Communications Decency Act, Section 230.
Well, I'm happy to start just with a sort of academic background, and then Haley and our friends at Nicosi can really speak to the practical impact of it. But as we talked about, Congress, in a rare moment of insight, saw something bad coming and wanted to protect it. And there were a couple different versions floating around, and they were eventually merged in the Communications Decency Act. And there is this very small section to the entire bill, but it's important to understand this section, both in its language and in its structure and in its history, was designed to be a very narrow defense for Good Samaritan companies. And I won't bore your listeners with all of the details, but just suffice it to say that in wanting to protect children and families and give them control over who could have access to children and what could be delivered directly to them, there was a bit of concern based on some cases that companies would not be incentivized to take information down because they might be sued by other bad actors, essentially. And so the idea was, well, we'll put in this provision here, and the provision is called Protection for Private Blocking and Screening of Offensive Material. And it is within the obscenity and violence section of the Communications Decency Act to do exactly that. Protect Good Samaritan companies who say this information looks like it's bad, we're a private company, let's get rid of it. That was the idea. And really, to understand Section 230 is to understand that it emerged out of this entire ecosystem of child protection.
That's exactly right.
But what happened is a very intentional campaign by tech companies. First, to get the language in that phrased in such a way that they would be trusted to take down material rather than to just simply not allow it at all. Secondly, they then marched into courts across this country and argued, no, the intent behind this is not a narrow Good Samaritan defense. It's in fact a very broad immunity so that we cannot be sued, states cannot enforce their own laws against us, and we face no liability for things that happen on our platforms that we don't directly cause, essentially. And that swept across courtrooms in America, and they turned this very narrow defense on its head to be this very, what I refer to as de facto broad immunity that has allowed them to function for the last nearly 30 years with impunity. That's what has happened within the courtrooms of America.
So, Haley, I know you want to add on to that, so you go for it.
Well, no, I mean, just everything you've said is exactly right. And we've just seen devastating consequences. I think the hope of the Good Samaritan exception was that people would be Good Samaritans. And the really disturbing thing is that using and weaponizing this idea of broad immunity, tech companies time and time again are therefore not prioritizing online safety. And this is my opinion. My opinion is that they're not prioritizing it because they know that if they're brought before a court after someone is hurt, they can just say that they're immune. And there have been so many whistleblowers who have come out, and so many cases, reports that have been leaked, for example, of companies getting thousands of reports of sextortion every week and ignoring them, reports of them having internal conversations and intentionally taking away safety mechanisms around potentially a new AI tool, for example, and because they want to drive up engagement. And despite warnings from their safety teams, doing that in order to drive up engagement. And then that AI tool has sexually explicit conversations with children. There's just so much data that we now have that this system is broken. And not only do we see that just from the numbers, but from the stories of these children, I mean, adults too,
Mhm.
who are being harmed online. And that's one aspect of our Dirty Dozen List campaign is naming or is telling the stories of some of these lawsuits that have been thrown out of court because of CDA 230, because of Section 230. And it's just heartbreaking when you hear these stories. And it just is so clear that this has to change. This status quo, we've seen the results of blanket immunity for big tech as interpreted by the courts. The results are not good, and it's time for us to change. Mhm.
Well, thank you for that. I want you to share, at least pick one survivor story of the 12, but I'm going to start with um, the first survivor I met. And this goes back to one of the first court cases where we knew we had a problem with CDA 230. And this is Jane Doe versus AOL. I was personally involved in that case, and I was also one of the advocates for the Good Samaritan defense. And just so your audiences understand, at the time, there were a couple of internet service providers. AOL was one, Prodigy, and they were filtering. They had a whole system set up to where for kids where they had the filter set up at their servers, and so it all made sense to us and made sense to Congress that if they had those filters on, and the filters weren't perfect then, they aren't now, but they were really not perfect then. And if something got through, pornography in this case is what we were talking about at the time, then even though they had filters in there, that they wouldn't be liable. And that's all that this was about. But we knew we had a problem when I got a call from Jane Doe in my office, and she was absolutely petrified. Her young son, there were images of him on AOL, and if his sexual abuse, we call that now child sexual abuse material, then we called it child pornography. And she had alerted AOL to take it down. They didn't take it down. It took them a number of days to take it down. And so I said, you got to hire a lawyer. And so we worked with her on that and her family to hire a lawyer, which they did, and they went after AOL. And I knew we had a problem. And Mary, I talked about this with you in our pre-interview. When AOL won that case, and they won that case by using 230, saying that they were not responsible. They had days, and we're like, wait, no. And I went to our team at the National Law Center for Children and Families, and Bruce Taylor and all the guys. We were very much behind CDA and 230 and everything else, and said, we've got a problem. And then it just snowballed from there. And so for me professionally, one of my professional goals is to see this whole CDA 230 get back to the congressional original intent. We're going to talk about what Congress is doing this year. But Haley, I want to go to you again real quick. Just share a story of one of the survivors, one of the 12 survivors, what happened, why they lost. Well, I think we know now why they lost, but just how devastating this is that these victims, these survivors, have no recourse.
Yeah, one story that is just really dear to my heart because one of our lawyers at Nkosi works with them. Our team works with this survivor in this case, and it was John Doe, who he was 13 years old when he met a stranger on Snapchat who posed as a girl who at his school and said that she had a crush on him. So they started messaging as young people might do, and this girl started escalating the conversation and eventually getting the young boy to send sexually explicit photos of himself. And unfortunately, as is a really normalized story now, that girl turned out to be a predator. It was a sex trafficker, an adult who was posing as a schoolmate, and that predator began blackmailing John Doe. Again, only 13. So all of these images were child sexual abuse material or child pornography. This abuser coerced him to create more images. Eventually, John got the strength to block this predator and to extract himself from the exploitative situation. But then a couple of years later, at that time, the trafficker told him, "You're making a mistake. I'm going to share these images of you." And a few years later, John discovered that those images and videos were posted on Twitter, now X, Twitter at the time. So he reached out to Twitter. He reported the material. Obviously, it was child sexual abuse material. It was non-consensually shared. Everything about it went against Twitter at the time's, terms of service. But the video remained up. Twitter even actually asked for proof of his identity and age. He sent in, his license information. I think it was his learner's permit because he still wasn't old enough for a license. But they still refused. They said, we've reviewed the content and did not find a violation of our policies. And so the videos remained on Twitter. They got over 165,000 views. He began to feel suicidal as people in his school found and circulated the videos and bullied him. And Twitter continued to refuse to take it down until finally, just through luck, the family found a personal connection at Homeland Security who eventually reached out to Twitter and got it removed. But this lawsuit has been ongoing. We're in the appeals process right now, but it's been continually uh, ruled by the courts that Twitter has complete immunity for this situation, even though they reviewed the content, they acknowledged to reviewing child sexual abuse material. They knew that this was not consensually shared and that he was a minor at the time in these images and at the time of reporting, and they left it up. And there were also ads running alongside this video. And so I just think that this is such a clear example of how egregious this broad immunity has started to become in the courts, because to knowingly have all of this information and to allow it up, in my opinion, is completely negligent and, if not willful, to allow this to continue on your site. And so I just think it's a clear example of how Section 230 is giving immunity to sometimes bad actors.
Oh, yeah. In this case, horrible, horrible actors. Mary.
Well, if I can just jump in on a few things, but everything that has been said is correct. First thing, just to underscore how bad the companies have perverted this law, for lack of a better word, is we talk about immunity because they've injected that into this discussion. Section 230 itself does not have the word immunity.
Okay.
It does not have that word, but that's how successful they have been in distorting this in courtrooms and in public policy. But to really underscore how bad this is, like, I hope your listeners can understand how bad this is. I can't think of another industry that when they make business decisions does not have to worry about any regulation and does not have to worry about being sued if they intentionally harm someone. That's how bad it is. And so to be clear, as we all know from the internet, one company, one platform, one startup, it doesn't matter, or something really big like Twitter, etc., can cause a vast amount of damage, as Haley's example just gave us, 145,000 looks of these images, monetizing these images, giving no control over the victim for it. And yet, there's no regulation and there's no other way to look under the hood and see what are the decisions this company is making, because access to justice is denied at the courthouse. These cases are dismissed. So I can't think of another industry that can cause so much harm with such little action, right, to so many people. And they have successfully precluded anyone from knowing the choices they're making, how they're designing their materials, how they are not accidentally, but intentionally facilitating this abuse. And I think that alone, you can pick any industry, food, automobiles, travel. We would never stand for that, for any industry that could harm a lot of people. And yet they've successfully managed to have it on their industry at the cost of our children.
That's right. And that's a great example. Look under the hood, right? So ladies, we all know that there have been some incremental positive changes by big tech, but that has come at a huge effort on the part of groups like all of ours and Nicosi and just just advocacy, public awareness in exposing and shining a light on this darkness. And of course, Senate hearings, etc. But what incentives, or are there any, do these big tech companies have to do the right thing, like default filter, which is something we want to see happen, safer by design technologies currently in the landscape of where we are right now?
There's no incentive for them to do the right thing. In a normal industry, they would think about doing the right thing because they would think about doing the right thing because they want to stay within the bounds of the law. But they've successfully precluded any meaningful regulation on them. So that's not an incentive to do the right thing. They would want to do the right thing in a normal industry because, gosh, if you recklessly design your product or you know that it is dangerous, which we know some of these companies have done because of whistleblowers, okay, they would say, gosh, well, we can't intentionally make this product addictive, for example, because we could get sued. They don't have to worry about that. So there literally is only an incentive to make money. And what we know about the business model of the internet, money is made by monetizing extreme content to get a lot of eyes looking on it and by obtaining as much private information about anyone, but particularly children, and making that available. A study at Harvard University estimated that the three, I think, biggest tech companies made 80, if I'm not mistaken, $80 billion, if I have my numbers right, off of this age group. And the Wall Street Journal reported that they spent nearly $100 million last year just defeating the Kids Online Safety Act. That is how much money is at stake here, that they're willing to spend that kind of money because they can make so much more money off of the exploitation of children and vulnerable people.
Right. And on that point of the study that the Wall Street Journal did, I wrote an article for the Washington Examiner called The $11 billion Reason That Big Tech was fighting this, and it was a shorter period of time, Mary, probably than what you were talking about. But these top internet companies, that was the ad revenue. That's just the advertising revenue that they were making for marketing information to kids, minor children under the age of 17 or 18, depending on the state.
And thanks for correcting me, Donna, because I think you're right. I think those are the numbers that we're talking about. So, and you're exactly right. Just the ad revenue, that's what they're making this in the billions of dollars. So spending almost 100 million to make sure that they don't have to do anything to protect children, that's an easy investment for them.
So I want to go back to the story, Haley, that you were talking about with John Doe. And the fact that Twitter, still, it sounds like to me, hasn't taken this down. Now, I'm going to introduce.
They did eventually.
Oh, they did. Okay.
It took a long time.
Okay. How is that now going to impact stories like John Doe, Haley?
Well, it's a very important law, and for those who weren't following it, essentially at the federal level, it criminalized for individuals uploading, sharing non-consensually shared explicit materials or non-consensually shared pornography. And it also, the most important part in my mind really, is made a requirement for online platforms to take down reported non-consensual material within a 48-hour window. And that stemmed out of the problem that these tech companies have not been doing that. We worked with survivors who for weeks and months and years worked with tech companies trying to get their materials removed. And it took them a long time and a lot of bureaucracy and jumping through hoops to try to get a non-consensually shared video, for example, recorded sexual assault, taken off or out of search results for their name. So this is a really incredible step forward. It certainly doesn't fix the CDA 230 problem, but I think we could see it really as a first chink in the armor of Section 230 because it does have a requirement for platforms to start doing the right thing. So I'm hopeful that not only is it good legislation, but I'm hopeful that it's a sign of things to come and of growing bipartisan support for putting more requirements on online platforms to do the right thing.
Exactly. And as you know, there are many bipartisan bills right now in the Senate, and that we all love and support, and we want to see happen because each one is taking a bite out of the elephant. When I say the elephant, protecting children and families online, by tackling a piece of this, right? And so, the old saying, how do you eat an elephant? One bite at a time. But I think we all agree that there's one way to just eat the whole elephant here. That's probably not the right analogy, and that is to see Section 230 amended, repealed, or sunsetted. So I want to get to this next because we know that in the very near future, Senator Graham, who is my senator here in South Carolina and a friend, will be introducing Sunset 230. So let's talk about that and ideally what that would look like. So Mary, I'm going to come back to you because I think you and I both agree that there is a piece in there that we would like to see stay, and that's the original intent of the Good Samaritan defense. Mary.
That's correct. When we hear people talking about sunsetting or repealing 230, the sentiment is exactly right. As you've alluded to and as Haley shared with us, the reason why this is happening, there is positive legislation that's floating around, although the Take It Down Act is one of the few bills that's been able to address some of this, that actually gets across the finish line. And that, frankly, reflects how much power big tech has in Washington and in Washington. But they have had to create these other bills because this is an industry that has created this de facto immunity for themselves. So the best way to address why the internet looks like it does, why it is the Wild West with companies incentivized to only make money and to not protect, is to remove what has become a de facto immunity for bad actions. And there's good precedent for this. If we think about history of industries in America, a lot of them start off without regulation. Like, let's just pick transportation. It's a really good one. Starts off without a lot of regulation at first, but then when it gets to the point where it's of such a size that it could really inflict harm, we traditionally then start to put in reasonable common sense regulations there to protect the American public. And that arc of history is repeated again and again in every major industry in the United States, except for this one. So the only way to have that arc of history play out is to repeal all those sections of 230 that have been morphed and deformed into not recognizable to their intent, but to keep just that language about it's labeled protection for Good Samaritan blocking and screening of offensive material. If we did that, then the legal incentive for companies is to remove that kind of material and to not worry that they could be sued by somebody saying, hey, that wasn't really CSAM, you shouldn't have taken it out. They won't be sued for that. So they're incentivized to be protective towards children and marginalized people, not how it is now where they're incentivized to intentionally facilitate harm if it is profitable.
Exactly. And we've been talking a lot about taking down content, right? And in particular, CSAM or pornography, et cetera, which kind of really goes back to the original intent of where the internet was back when CDA was initially passed. But big tech, I used to say, technology is neutral. It's the bad actors that are misusing it. But that's no longer the case because now we know these big tech companies are intentionally programming and setting up their algorithms to put harmful content in front of kids, to hook kids, to get them addicted. I mean, sleep deprivation is huge, suicide is huge. The last Surgeon General put out a whole piece of work and statements and everything saying that social media is one of the largest public health issues of our time. And social media was playing a role in that. So Haley, I know you see a lot of this in your work. Do you want to comment on that? And then we're going to get to, have we learned anything? And I think you're going to find out we really haven't. So, but Haley, let's start with my first question to you.
Yeah, I would just add that I think that design, the way that these systems are designed and that no longer being neutral is such a good point, Donna, because I think one example is the ability for these platforms to connect adults or predators with children is a huge problem. And that's been an existing issue on social media companies, on dating apps. I mean, Grindr just recently had a case that got kicked out of court because of Section 230 of the CDA, where this dating app put a minor in touch with four adults who then sexually assaulted him. And that connection point, the recommendations, the doors that these platforms open, where literally a child who never would have met a predator before is then served up to someone who has the intention of abusing them, is just completely unacceptable. So I just think that and so many other things point to the need for these companies to have the incentive, because they're truly building them without that safety feature in mind.
We're going to wrap now, all right? And while you're thinking, how do I protect my kids in this toxic digital world? Many of us are out there trying to help you. We believe at Enough is Enough that parents are the first line of defense. They certainly can't enforce the law. They can't pass the laws. They can't make big tech do what needs to happen, except with their purse, but you can protect your own children. So at InternetSafety101.org, we have lots of free resources, guides to help you on every major danger that your kid can come across online, whether it's pornography, sextortion, bullying, anything. What you need to know as a parent: what are the red flags? What are the warning signs? Conversation starters, guides, you name it. So please go to InternetSafety101.org. Ladies, please let the audience know how they can reach you, or any final remarks you'd like to make before we wrap.
On my end, you can go to endsexualexploitation.org, or if you want to contact your legislators with an easy email, a click and 30 seconds around CDA 230 to encourage them to change CDA 230, you can go to dirtydozenlist.com.
Thank you, Haley. Mary?
And I would just say to your listeners, what is uniquely dangerous about what we're talking about is with the AI, you can have a child or any person not engaged in any risky behavior, making all the right decisions in the world, okay? Every single decision. Not that even if you engage in risky behavior, you should be harmed. I'm not suggesting that. But just by having their photo somewhere, someone can victimize them in the way the Surgeon General has warned us about, in the way the FBI has issued a warning about. So this is an issue for everyone. If I can be of any help with legal analysis or articles or whatever, I can be reached at the Catholic University of America, and my email is leary@law.edu.
Well, thank you both so much. I mean, this has been a very robust conversation, a very eye-opening conversation. And I want to leave our audience with this. We all know we're living in a very divisive world, but protecting children online is a nonpartisan issue that has wide bipartisan support at the federal level and at the state level. And last year, we wrote the Children's Internet Safety Presidential Pledge. We did one in 2016 and 2020 as well. And we are calling on, and we got a whole coalition of nonprofits calling on President Trump to prioritize protecting kids online. And we've already seen him appoint an attorney general who is terrific and at getting the existing laws enforced, and we're going to be working hard on that. But one of the provisions, one of the recommendations we included was also the importance of this president and this administration supporting congressional efforts to amend 230. So please stay tuned, sign up at our website, InternetSafety101.org, for free newsletters. And we'll keep you updated on when Senator Graham introduces Sunset 230. And of course, you can sign up at Nicosia as well. And just know that there are a lot of us out here, hundreds of organizations that are fighting for you. We're fighting for your family. We're fighting for your children so that they can enjoy this digital world free from exploitation. So thank you so much, everyone, for joining us. If you like this podcast, please share it. And in the words of one of my dearest friends, if you see someone without a smile today, give them one of yours. Thanks, everyone.
Thanks for tuning in to today's episode of Internet Safety with Donna Rice Hughes, designed to educate, equip, and empower you to keep your children and family safe in the digital world. Until we talk again, have a beautiful and safe week.